How's it going, guys? Andre Issa here, your friendly neighborhood employment lawyer, and today we're going to be talking about summary dismissals in Ontario. But before we get into it, guys, I just wanted to put a very brief legal disclaimer out there. None of what I'm about to say constitutes legal advice. It's just legal information. If you believe that your employer has violated your rights, you are welcome to contact me or any other employment lawyer in Ontario. Okay, so with that out of the way, guys, I just wanted to start off with a quick hypothetical scenario just to get you guys thinking about summary dismissals. I want you guys to imagine that you're a car salesperson in Ontario, and unfortunately, you were charged with drug trafficking after hours of work. Can your boss fire you on the spot for that, or does he have to give you notice? In this video, you're going to learn that an employer has the right to fire you on the spot in Ontario if you have committed a fundamental breach of your employment contract. This type of termination is what we call a summary dismissal for cause. The Ontario Court of Appeal explained summary dismissal in the 1967 case of Crown and Arthurs. If an employee has been guilty of serious misconduct, habitual neglect of duty, incompetence, or conduct incompatible with his duties or prejudicial to the employer's business, or if he has been guilty of willful disobedience to the employer's orders in a matter of substance, the law recognizes the employer's right summarily to dismiss the delinquent employee. Now, you might be wondering, why should I care about summary dismissals for cause? Well, the reason why you should care is because if you were in fact legally fired for cause, that means your employer does not have to give you notice to dismiss you. That notice, of course, equals money that you would otherwise be entitled to as an employee in Ontario. However, if you were legally fired for cause, you are no longer entitled to that money. Now, remember what I said just there. Legally fired for cause. In other words, just because your boss said that you're fired for cause, or that he or she has grounds to fire you for cause, that doesn't necessarily make it true. The leading test for determining whether or not an employee's conduct amounts to cause for dismissal is found in the Supreme Court case of McKinley and BC Tel. What happened in this case was that the employee unfortunately suffered from high blood pressure, and his doctor told him to take a leave from work. The doctor eventually told him that he could return to work provided that he took a drug known as a beta blocker. The employee never told the employer about this other option. Instead, what the employee asked for from his employer is to move him to a less stressful job. The employer refused to accommodate the employee and instead decided to fire him without notice. The employee subsequently decided to sue the employer for wrongful dismissal. At trial, the employer claimed that he had grounds to fire the employee for a cause, so summarily dismiss the employee, because the employee had essentially lied to the employer. He had never told the employer that one of the options, according to the doctor, was that he could return to work provided that he took beta blocker medication. And so the question for the court was, did the failure to disclose the fact that his doctor had instructed him that one of the options was to take beta blocker medication, and in so doing he would be able to return to work, was that dishonesty that sufficiently amounted to cause for dismissal? And in considering this question, the court came up with a two-part test. Step 1. Did the employer establish on a balance of probabilities that the employee breached the contract? Step 2. Is the employee's misconduct sufficiently serious that it undermines the foundation of the employment contract? And in considering this two-part test, the court concluded that no. While the employee may have been dishonest to his employer, things need to be looked at as a whole. And overall, this dishonesty was trivial and it didn't amount to a fundamental breach of the employment contract. And so therefore, the employer was not allowed to fire the employee without giving him his legal notice. And in case you're wondering how much the employee got because of this, he got 26 months of reasonable notice. Meaning, if, for example, the employee was getting paid, all things considered, $10,000 a month, that's just over $250,000. So, now that we've gone through the legal test, let's run through some examples of what does and doesn't amount to cause for dismissal. Remember I gave you that example at the beginning of this video about how you're a car salesperson and you were charged with drug trafficking after work hours? Well, I never really answered that question. Can you get fired for that or not? Well, based on the case of Backman and Hyundai Auto Canada, the answer seems to be no. On the other hand, in the case of Whitehouse and RBC Dominion Securities, an investment advisor brought a sex worker to his office after hours, and that was enough to fire him for a cause. I use these two examples to show you that while they might seem similar in some ways, there were two completely different outcomes. And that's because every single fact scenario is different. If you believe that your boss illegally fired you for cause in Ontario, contact me today and I can review the facts of your case and let you know, in my professional opinion, whether or not I think that you were in fact legally fired for cause, or whether you were illegally fired for cause because it does not meet the threshold of the two-part test that I mentioned in this video, and how much money I think that I can get you. This has been Andre Issa, your friendly neighborhood employment lawyer, and until next time.